Welcome, everyone. Over the next hour, I want to take you inside the consultation room. Not the textbook version of immigration law, but the version that actually walks through the door. Messy timelines, half-finished applications, a passport that expired at the worst possible moment, a marriage that is real but hard to prove, a refusal that arrived the week before a deadline. These are the real problems people brought to us with the identifying details stripped out. For each one, I will do three things: tell you what the person wanted to consult about, name the laws and government policies the conversation turned on, and walk through the solutions we discussed. My goal is that by the end, you can hear a new fact pattern and immediately start spotting the issues and the moves that lawyers have to partake in. I've tried to group the cases into themes: the permanent residency obligation, citizenship and presence, family sponsorship, study and work permit status, misrepresentation, express entry and provincial nominees, as well as business and investor entry, and finally, inadmissibility, refusals, and last resort remedies. So let us begin. As you listen, watch for three recurring patterns. First, the small administrative fact that turns out to be the whole case: an expired passport, an omitted job, a corrected name. Second, the timing trap, where a deadline or lapse in status forecloses the best option. And third, the disclosure choice, where the safe move is almost always to surface a problem and explain it, rather than hope an officer misses it. If you start hearing those three patterns under the surface of each story, you are already thinking like the person on the other side of the consultation table. One note on how a consultation is actually structured, because it shapes everything that follows. We try to work through five things in order, ideally. For example, the chronology of what happened and when, the background facts about the person, their family, and their work, if applicable, the core issue or issues those facts create, the person's goal, and only then the advice. The discipline matters. A great many refusals, particularly of self-filed candidates for visas, trace back to a chronology that did not hold together or a background fact that surfaced too late. Each case below moves through that same arc, compressed into a few sentences. So let's dig in. For example, permanent residence and the residency obligation. Permanent residence is not permanent if you do not live here in Canada. The residency obligation in Section 28 of the Immigration and Refugee Protection Act asks a simple sounding question: were you physically in Canada for at least 730 days in the last 5 years? And that question can quietly unravel a status someone has held for decades. Here is how it shows up in real life. The first case: the permanent resident whose passport could not be renewed. A client wanted to consult about protecting his permanent resident status while he was stranded outside of Canada by forces entirely beyond his control. He had landed only a couple of years earlier, spent very little time physically in Canada, and his permanent resident card was on a path to expiry well before he could meet the residency obligation. On top of that, his country of citizenship had stopped renewing passports for men of his age cohort who were abroad in order to pressure them to return and be available for military mobilization in that country. So even his travel document was about to become unusable, and he feared being effectively forced home. The questions raised touched upon the laws of Canada, and the particular law was Section 28, the residency obligation under IRPA, and the consequences of accumulating too few days inside of Canada. So in this situation, the option of a permanent resident travel document abroad without a valid card and the humanitarian and compassionate relief built into the residency obligation assessment for circumstances outside the person's control. The possible solutions discussed included front-loading time in Canada as soon as he could enter, documenting the conscription and passport situation as humanitarian factors to offset the shortfall in the 730 days, planning the timing of any travel document or card renewal request very carefully, and preparing for the possibility of a residency obligation examination and, if needed, an appeal to the Immigration Appeal Division. So that's one example. In another case, this is the card that ran short of days. A client wanted to consult about returning to Canada when he already knew he had not met his residency obligation. He had spent long stretches abroad, his card no longer reflected enough days inside Canada, and he was weighing how to get back to Canada. The questions raised touched upon the laws and government policies relating to the residency obligation, the permanent resident travel document process for someone outside Canada, and what actually happens during examination at a port of entry. The possible solutions discussed included a frank assessment that a travel document application, in many cases, has a low probability of success depending on the situation, especially in this person's circumstances. Also, the alternative of presenting at a land crossing, where the chance of obligation being assessed and closely scrutinized is a real one, but not certain. And critically, that if he did get into Canada, how he could rebuild his days, with a practical floor to 2.5 years being the amount of days ideally to be in Canada before officially renewing the status of the permanent resident card. We also flagged that processing times for a new card vary and cannot be promised. In a similar case, this was the lifelong permanent resident who wanted to move south. A client in his mid-20s, a permanent resident essentially his whole life, wanted to consult about relocating to the United States while staying on the payroll of his Canadian employer, which had US branches. The wrinkle was that the Canadian branch, not the US offices, assigned his work. The questions raised touched upon the laws and government policies related to how time spent working abroad can or cannot be counted toward the permanent residency obligation. Specifically, a rule that employment outside of Canada for a Canadian business can count only when the assignment is genuinely a posting by that business. And related, the risk of crystallizing a residency obligation problem by moving before the question is nailed down. The possible solutions discussed included structuring the arrangement so the work abroad is a true assignment of the Canadian business, if that is the goal, keeping meticulous records of the employment relationship, and if the move is really to live in the United States indefinitely, having an honest conversation about whether Canadian citizenship should be secured first. Another situation from permanent residency to citizenship, the presence and disclosure. Citizenship has its own arithmetic, 1,095 days of physical presence in the 5 years before applying, and its own honesty requirements. 2 consultations we had show how easily people stumble around at the edges. In this particular case, a person landed on the portal, then left the country. A client wanted to consult whether the way he became a permanent resident could come back to haunt a future citizenship application. He had completed his landing through the online portal while he was physically present in Canada and truthfully declared his presence on that date. Shortly after, he had to return to his home country. And he asked the processing office whether anything needed to be done first. He was told to notify them by email that he was leaving, did so, and then received his electronic confirmation of permanent residence while already abroad. His worry, if he later applies for citizenship, will an officer see that he was not in Canada on the day the confirmation issued and treat it as a problem? The questions raised touched upon the laws and government policies related to Portal-based landing as a permanent resident, the meaning and confirmation of permanent resident date versus the date presence in Canada was declared, and how physical presence is counted for citizenship. The possible solutions discussed included keeping the full paper trail of his declared presence and his notice to the office, understanding that his physical presence clock for citizenship runs on days actually in Canada, regardless of where the confirmation document was delivered, and being ready to explain the sequence simply if ever asked. Another case, a citizenship application from across the border. A client wanted to consult about a citizenship application she had filed and then complicated by moving to the United States without updating her address. While her travel history was extensive and she expected officers to want to see the stamps. Her card was a couple of years from expiry and an interview was approaching. The questions raised in this scenario touched upon the laws and government policies related to the physical presence requirement for citizenship, the duty to keep the immigration department specifically informed of address changes, and how heavy travel and a move abroad mid-process during citizenship invite scrutiny and presence of the citizenship department. The possible solutions discussed included reconstructing her travel record precisely, including whether her US entry and exit records to corroborate days, correcting the address on file, and going into the interview able to account for every absence so that the presence calculation holds together. Another case related to, this time, spousal, common law, and family sponsorship. So this is a completely different area. Sponsorship is where the law meets people's actual lives and where genuineness, timing, and disclosure collide. The relationship can be entirely real and still hard to prove. A small inconsistency in a name or a date can trigger a procedural fairness letter, and a child's status can change the whole strategy. In this case, a real marriage and a name that did not match. A client wanted to consult about sponsoring a spouse where the relationship was genuine, but the principal applicant had a name discrepancy across his documents. His identity records were consistent, except that a birth certificate had been corrected to the proper name, supported by an affidavit, and earlier temporary status applications had used an uncorrected name. The questions raised touched upon the laws and government policies related to, in Canada, spousal sponsorship, the genuineness assessment of the relationship, and the serious risk that an unexplained name inconsistency across prior applications could be characterized as a material misrepresentation under Section 40 of the Immigration and Refugee Protection Act. The possible solutions discussed included assembling the affidavit and corrected records into a clear, preemptive explanation of the name history, choosing the in Canada route with its open work permit option where appropriate, and getting ahead of the issue in the submission rather than waiting for a procedural fairness letter, which could end up in a 5-year ban. Another case related to marriage and sponsorship, a refused sponsorship, a departure order, and a marriage to prove. In this case, a client wanted to consult after an in-Canada spousal application was refused following an interview, leaving the applicant with a departure order, which is a form of deportation. An earlier temporary resident permit had also been refused, and an express entry profile was withdrawn. The officer's concern had centered on the genuineness of the marriage, which was a same-sex marriage that the couple had not disclosed to most of their families, and the interview had probed who in the family knew. The questions raised touched on the laws and government policies related to the bad faith relationship rule that lets officers refuse where a relationship is not genuine or was entered primarily for getting status, the evidentiary challenge of proving a genuine relationship that has been deliberately kept private, and the effect of a refusal that carries a removal order. Possible solutions discussed included building a fuller evidentiary record of the relationship, shared finances and life together, explaining sensitively why the relationship was not broadcast to the family, and weighing the available recourse against the departure order and the timeline that the departure order creates. A different case, when the baby's citizenship freezes the parent's sponsorship. In this case, a client wanted to consult about an outland spousal sponsorship of a stateless spouse born abroad to parents from a community without citizenship there. That had been put on hold by a procedural fairness letter. In the middle of processing, the couple had a child abroad at a time when the sponsoring parent was already a citizen, and they filed for the child's Canadian citizenship certificate. The department's position was that because the child was eligible for citizenship by descent, the child could not be processed as a sponsor dependent for PR, and the spousal sponsorship would wait until the child's citizenship was sorted out. The questions raised here touched upon the laws and government policies related to citizenship by descent for a child born abroad to a citizen parent, the interaction between citizenship claims and a dependent child processing in a sponsorship, and statelessness as a complicating factor. The possible solutions discussed here included pressing for the citizenship certificate to conclusion to unlock the held sponsorship, managing the parallel medical and processing steps so nothing lapsed, and corresponding with the office that's relevant, Citizenship and Immigration, to request status updates to avoid the file stalling indefinitely. In a different case, under a removal order about to marry a permanent resident. In this case, a client wanted to consult who was already under immigration control, a negative pre-removal risk assessment behind him, reporting to the department roughly every 2 months, and a passport that had expired years earlier, and who was in a relationship with a permanent resident and about to marry. Very complicated. The questions raised in this scenario touched upon the laws and government policies related to the consequences of a negative pre-removal risk assessment, ongoing reporting obligations to the Canada Border Service Agency, the difference between marrying a permanent resident versus a citizen for sponsorship purposes, also the 12-month cohabitation threshold for common law status, and the request that he sign a travel document to facilitate removal. The possible solutions discussed included assessing whether a spousal or common law sponsorship could realistically be advanced, given his status, the strategic significance of his refusal to sign a voluntary travel document, and a candid view of how the removal machinery and any sponsorship would have to be sequenced. In a different case, this is one where the returning resident and the parent supervisa, after a refusal, transpired. A client wanted to consult about a tangled family life with 2 parts. Years earlier, a family member had come as a refugee, then returned overseas without the departure record that would later be needed, raising a likely authorization to return problem. More recently, a parent sponsorship and supervisa history had gone sideways. A sponsorship of the parents was refused, or rather of the couple was refused, on a marriage of convenience concern involving a remarriage within the extended family, and a supervisa for the father had been refused more than once at interview. The questions raised touched upon the laws of and government policies related to the authorization to return to Canada after removal, a removal option, the missing certificate of departure, the marriage of convenience basis for a sponsorship refusal, and the supervisa requirements for parents and grandparents. The possible solutions for this discussed included obtaining the underlying records through an information request to reconstruct the complexity of what happened, addressing the authorization to return issue head-on, and rebuilding a super visa application that directly answered the officer's prior concerns about genuineness and ties to the home country. In a different case, excuse me, the spouse who needed to keep working while the sponsorship ran. A client wanted to consult about keeping a spouse employed while an in Canada spousal sponsorship was in process, where the spouse held an open work permit tied to that pending application, and the renewal had been refiled as the underlying study to work history wound down for that person. The recurring worry in these files is a gap in authorization that interrupts both work and the sponsorship. Because if there is a gap from student to work, for example, a gap leading to no status or visitor status, then there would be no longer a seamless ability to transition from student to work or from work to a new work permit authorization. The questions raised here touched upon the laws and government policies related to the spousal open work permit available under the public policy to applicants in the in Canada class. Also, the issue of maintained status while the renewal is pending, and how the work permit's validity is anchored to the sponsorship itself. Possible solutions in this scenario discussed included filing the renewal in good time, relying on maintained status to continue working while it is decided, and making sure the open work permit and the sponsorship were aligned so that a problem with one did not quietly undermine the other. On a different matter, altogether, study and work permits, for example, status, the hour per week limit, and the port of entry types of issues. So keep in mind, temporary status is fragile. It depends on maintained status while an application is pending, also on respecting the conditions of a study permit, and also on what an officer decides at the border and or port of entry. These consultations show how quickly a routine file becomes a status emergency. In this case, implied status and the trip she could not safely take. A client wanted to consult about whether she could leave Canada to see a seriously ill parent while a post-graduation work permit extension sat in process without conclusion. She was relying on maintained, previously called implied status. Her spouse was likewise waiting on a permit, and she had been in a field where any gap in authorized status did matter. The questions raised touched upon the laws and government policies related to maintained status while an application is pending, the rule that maintained status does not travel with you the way a valid permit does, and the risk that re-entering during processing could cost her the very status she was trying to preserve at the port of entry. The possible solutions discussed in this scenario included understanding precisely what maintained status does and does not protect, weighing the family emergency against the concrete risk of being unable to resume work on return, and planning any travel only with a clear-eyed view of how she would be examined by an officer coming back. In a different case, the student who worked too many hours. A client wanted to consult about a post-graduation work permit application where the underlying study permit conditions had not been perfectly observed. During a term of study, he had worked well beyond the off-campus hour limit that applied at the time, including stretches of 35 to 40 hours a week and weeks over the cap paid by check, thus a paper trail. The questions raised touched upon the laws and government policies related to the off-campus work hour conditions attached to a study permit, also the consequences of breaching a work permit or study permit condition for post-graduation work permit eligibility later, and how to honestly characterize the work history. In this case, the possible solutions discussed included a careful reconstruction of which periods complied and which did not, an honest assessment of the eligibility risk that overwork creates, and how to present the application without compounding the problem through omission. In a different case, two refusals at once, a study permit and work permit. The client wanted to consult after both the study permit matter and a post-graduation work permit were refused in the same window. She had studied at a college, graduated, but had to repeat a couple of subjects, and her file had been dogged by administrative problems. A tuition payment the college had not recorded, and a bank delay that went months without resolution. The questions raised here touched upon the laws and government policies related to post-graduation work permit eligibility, where a program was not completed cleanly and seamlessly, and also the evidentiary importance of proof of payment and continuous enrollment, and possible options after a refusal. The possible solutions discussed here included gathering documentary proof to cure the record-keeping gaps, assessing restoration of status where the timing allowed, and deciding between a reconsideration request and a fresh, better documented application. In a somewhat similar case, but different, this was the permit lost to an expired passport. A client wanted to consult about a post-graduation work permit that had effectively been cut short because her passport expired, after which a further application was refused on the basis that she had only ever held one such permit and was told she needed to apply for an extension. The questions raised in this scenario touched upon the laws and government policies related to how a permit's validity is tied to its passport validity. Further, the one-time nature of the post-graduation work permit, also the issue of restoration of status, and the pivot from temporary status toward permanent residence. The possible solutions discussed included assessing restoration where available and, given her profile and her express entry standing, mapping a provincial nominee route alongside the federal pool as a more durable path, with attention to her work experience and language results. A somewhat different case now, the 3-year permit recorded by phone and the biometrics surprise. A client wanted to consult about a post-graduation work permit where an officer had, on a call to the department's contact center, noted internally that a 3-year permit applied, while separate biometrics requests that took place had arrived in connection with the paper filing. And a provincial master stream nomination was already in motion with an invitation in hand. The questions raised here touched upon the laws and government policies related to post-graduation work permit length, the reliability of an internal note made over the phone to an officer versus the document issued by the department, biometrics requirements on paper applications, and how a pending provincial nomination interacts with maintaining status. The possible solutions discussed included confirming the permit length on the face of the document rather than relying on a inter-immigration office call note, completing biometrics promptly, and sequencing the provincial nomination and permanent residence steps so status would not lapse. In an additionally different case, the long-term student planning her next degree. A client wanted to consult who had studied in Ontario for several years, high school here, then a business management program, and planned to transfer her credits into a 4-year bachelor's degree, and who had also changed her name legally. The questions raised in this very complex situation touched upon the laws and government policies related to study permit conditions across a range of program and institutions, the need for documents and applications to reflect a legal name change consistently, and how a continuous study pathway supports later work and permanent resident options. The possible solutions discussed in this scenario included keeping the study permit aligned with the new program, ensuring the legal name change was reflected uniformly across her records to avoid a discrepancy later, and looking ahead to the post-graduation work and permanent resident routes her Canadian education could open. Now a different case, the business owner who went back to school. The client wanted to consult about a permanent residence plan for a couple where the husband, already an established business owner here, where he had bought a printing and small manufacturing operation in Canada years earlier, was finishing a 2-year graduate certificate and considering enrolling in a further master's program with a young Canadian child in the picture, and the goal of permanent residence for the whole family. The questions raised here touched upon the laws and government policies related to a study permit for the further graduate program, the way ongoing and study plus business ownership interact, and the menu of permanent resident routes, for example, federal economic programs and provincial streams, that a profile combining Canadian education, Canadian business, and a Canadian citizen child can access. The possible solutions discussed here included securing the study permit for the master's program if continued study did make sense, mapping the strongest permanent resident pathway given the business and family ties, and timing the steps so temporary status carried the family through to a permanent residence decision. Now a completely different set of consultations: misrepresentation and the duty of candour. A theme runs through many of these files. Section 40 of IRPA, misrepresentation, and the 5-year ban that follows. The cure is almost never to hide the problem. It is to disclose and explain it before an officer finds it. One case crystallizes the point. In this case, the study permit that left out a job. A client wanted to consult whose earlier study permit application had omitted a year of employment abroad. He had been advised at the time when he filed for his study permit simply to leave it off, and who now had documentary proof of that job, including salary records and a later application in which the work permit experience would naturally resurface. The questions raised here touched on the laws and government policies related to misrepresentation and the duty to provide complete and truthful information, the way an omission in one application can poison later applications like PR, and how prior gaps and prior advice are assessed. The possible solutions discussed including the previously omitted employment now with the supporting proof, and framing the correction transparently so that the record is consistent going forward rather than carrying an undisclosed discrepancy that could later be characterized as misrepresentation. There are still risks in the strategy, but clients should be informed through a more diligent consultation about whether the strategy actually works in their case. Now, in a completely different set of factors related to express entry, the comprehensive ranking system, or CRS, and the provincial nominee route. Most of the economic consultations related to these programs come down to a few levers: how the work is classified under the National Occupational Classification, where the points come from, and whether a provincial nominee program can bridge a gap that the federal score cannot. Here is a cluster of them. In one case, French points and a job in another province. A couple wanted to consult about reaching permanent residence through express entry where the principal applicant score sat in the low 500s. Both held Canadian credentials, and one of them worked for an employer based in one province while the family lived in another. They were considering investing months to push French to an intermediate level skill for the additional points. The questions raised here touched on the laws and government policies related to the comprehensive ranking system, the bonus for French language ability, and how working and living across provincial lines interacts with provincial nominee eligibility. The possible solutions discussed included a realistic timeline to achieve the targeted French level and the points it would add, comparing a straight federal CEC route, for example, against a provincial nominee stream, and choosing the province whose stream best fit their occupations and location. Now, a different case. This one is something called laid off in the middle of the profile. A client wanted to consult about an express entry profile that relied on Canadian work experience just as her job was disrupted. A layoff connected to broader trade and tariff turmoil, a return to work, then a termination with a provincial nomination also in process, and invitation arriving in the same period. The questions raised touched on the laws and government policies related to how Canadian work experience is counted and documented, the effect of a layoff and re-employment on a profile, and provincial nominee processing timelines. The possible solutions discussed included pinning down exactly which periods of employment were provable with pay records, reconciling the profile with the disputed timeline, and sequencing the provincial nomination and the federal invitation so the application rested on solid, documented experience that would satisfy an officer to visa issuance for PR. Now, the other case, arranged employment points and an employer with a track record of refusals. A client wanted to consult about an invitation to apply that depended in part on arranged employment points, where the employer would need a labor market impact assessment, but had a history of such assessments being rejected, and where the client's score without those extra points still sat just under the threshold. A provincial foreign worker stream tied to the same job offer was also on the table. The questions raised here touched on the policies related to arranged employment and the labor market impact assessment, which is highly policy-based, and also the risk that a shaky assessment poses to an application built on it, the occupational classification of that role, and the provincial nominee alternative. The possible solutions discussed included assessing how realistic a positive assessment was given the employment's record, or the employer's record, building a fallback that did not depend on those points, and weighing the provincial foreign worker stream as a parallel or primary route to the LMIA. Now, a different case. A capable couple, a low score, and funds just short. A client wanted to consult about an express entry plan for a family where both adults had solid occupations, one in network administration/security, but the score sat in the mid 400s. Settlement funds were modestly short of the requirement, and there were several young children, one with significant medical needs. The questions raised here touched on the laws and government policies related to the comprehensive ranking system, proof of funds requirements, and how home equity does and does not count towards the settlement funds, the educational credential assessment, and medical admissibility factors for the dependent child. The possible solutions discussed included building the express entry profile while shoring up provable settlement funds, completing the credential assessment, and being clear-eyed about the score needed for an invitation to apply, and the admissibility of the child's medical needs, which can lead to possible refusal. Now, on a different matter, the licensed professional spouse. The client wanted to consult about permanent residence options for a family whose strongest asset was a spouse already licensed to practice a regulated health profession in more than one province, with the family otherwise established and fluent in English. The questions raised here touched on the laws and government policies relating to category-based selection that targets specific occupations, including healthcare, and how an existing Canadian professional license strengthens a profile. The possible solutions discussed included positioning the licensed professional as the principal applicant, watching for occupation-targeted draws, and assessing whether a provincial stream aimed at that profession offered a faster path than the general pool. Now, a different case, getting the occupation code right. A client wanted to consult about an express entry profile where the central question was how to classify her work. Her foreign work experience as a customer account resolution specialist and her Canadian experience with a registered charity each mapped to more than one possible NOC occupational code, and the right choice materially affected eligibility. Her score sat in the mid 400s, and her status as a common law partner was about to crystallize. The questions raised here touched on the policies related to the occupational classification under the National Occupational Classification, also the evidentiary need to match duties to the chosen code, and how common law status affects an application. The solutions discussed included a careful duties-based analysis to select the most defensible code, documenting the day-to-day work to support it, and timing the application around the common law milestone. Now, a different case. The recent graduate who wanted every option on the table. A client wanted a consultant who had arrived years earlier on a study permit, completed an engineering degree at a major university in Canada, was now working as an engineer for a large employer, and had already submitted a PR profile sitting at the mid 400s with a post-graduation work permit a couple of years from expiry. Her request was straightforward. Review the application already in and walk through every provincial option before committing. The options raised touched on the laws and government policies related to the comprehensive ranking system, the provincial nominee streams open to in-demand graduates and tech workers, and how a pending federal profile coexists with a provincial PR application. The possible solutions discussed included a side-by-side review of the federal pool against the relevant provincial streams, identifying which stream her occupation and score best fit, and keeping the work permit and status stable while the strongest route was pursued. Now a different case. The accomplished couple with no Canadian job offer. The client wanted to consult about permanent residence for an older professional couple, both with master's degrees, both fluent in English, one still working and possibly consulting in the future, who had no prospective Canadian employer and were conscious that age weighs heavily against them in the points system. The questions raised touched on the laws and government policies related to the comprehensive ranking system and how age, education, and language interact with it, and further, the absence of arranged employment and whether a provincial stream could offset a federal score that age alone pulls down. So the possible solutions discussed include a candid scoring of where they actually stood, exploring provincial streams with those which were less sensitive to age or aimed at their professions, and considering whether a Canadian connection, such as work or study, could be built to strengthen the profile. Two more brief variations on the same theme because they come up constantly. One was a software professional weighing whether to apply as a single applicant now or waiting for a partner abroad, where the marital status itself moved the CRS score. Was a worker whose Canadian and foreign experience each mapped to more than one occupation. In every one of these, the consultation turned on the same levers: the ranking system, the occupational classification, and provincial streams. And the same advice: model the score under each scenario before you file, so letting the numbers, not the hope, choose the route. And now a different case. I call it single now or wait for a partner abroad. A client wanted to consult about timing an express entry application. The software engineer, with about a year of Canadian work experience and a score in the low 470s, engaged, but not yet married, with a fiancé still overseas who might come as a student in a year or two. His Canadian work history included time with an employer that was the local arm of a foreign company. The questions raised touched on the laws and government policies relating to how marital status and a spouse's factors affect the comprehensive ranking score, how Canadian versus foreign work experience is counted, and the strategic timing of an application around a change in marital status. The possible solutions discussed included modeling the score as a single applicant now against the score if he waited and applied with a spouse, and also documenting the Canadian experience precisely and choosing the filing moment that maximized the points rather than defaulting to whichever came first. Now, a different situation: the two Canadian credentials and a job offer in hand. The client wanted to discuss who had held a foreign bachelor's degree in a technical field plus two Canadian postgraduate credentials, had recently begun an employer-supported role in one province, and had additional foreign work experience behind him. The question was how to convert that into permanent residence quickly. The questions raised here touched on the policies related to occupational classification under the NOC, the weight of Canadian education and a registered job offer in the ranking system, and the provincial streams that reward exactly that combination of Canadian study and local employment. The possible solutions here discussed included confirming the right occupational code for the role, leveraging the Canadian credentials and the job offer in both the federal pool and a provincial stream, and sequencing so that work authorization stayed continuous through to a decision. Now, a totally different category: business, investor, and cross-border entry. A different client profile: people who move because their business moves. Here are the tools related to this, which are work permits for intra-company transferees, business visitor rules, and the interplay with the United States investor status. One case: moving a key person into a family-owned multinational. A client wanted to consult about bringing a senior person from a family-owned manufacturing and trading business with branches across several countries and a workforce in the hundreds into a newly opened Canadian company tied to a relative here. The principal had a relevant professional degree and had run the overseas operation. The questions raised here touched on the policies related to the intra-company transferee work permit for executives, managers, and specialized knowledge workers, the requirement of a genuine and qualifying relationship between the foreign and Canadian entities, and the supporting business case. In other words, did it make business sense to open the Canadian branch? The possible solutions here discussed included documenting the corporate relationship and the transferee's qualifying role, preparing a business plan to support the Canadian operation, and structuring the entry as an intra-company transfer with permanent residence as a later objective. In a different case, the US investor who needed to step into Canada. A client wanted to consult who held United States investor status and needed to enter Canada. In one variation, a family of investors whose child's travel authorization had lapsed and who had recently received a visitor refusal. In another, an investor who simply needed to cross into Canada briefly to satisfy a US employment requirement that to periodically leave the United States despite an old visitor visa refusal on file. The questions raised here touched on the policies related to temporary resident visas and electronic travel authorizations, how a prior refusal is weighed, and the genuineness and dual intent considerations for short visits. Possible solutions discussed here included preparing a visitor application that squarely addressed the earlier refusal and demonstrated ties and purpose, sorting out each family member's correct travel document, including for a minor, and timing the Canadian entry around the United States processing time so the two did not collide. Now, in a different scenario, the executive of a family manufacturing business. A client wanted to consult who had entered on a visitor basis and was an executive director of a family-run garment manufacturing business. The family owned the factory and the parent was the chief executive, and who was exploring how to establish the business in Canada. The questions raised here touched on the laws and government policies relating to business visitor activities versus work that requires a work permit, also the intra-company transferee route for moving an executive into a Canadian arm of the business, and the longer-term permanent resident options tied to entrepreneurship and business establishment. So the solutions discussed here included staying within the permissible business/visitor activity in the short term so as not to break the law, assessing whether a qualifying Canadian entity could support an intra-company transfer, and sketching a route from temporary business activity toward a more permanent business immigration plan. So that was one scenario. If you're just joining, we have a few minutes left. This is the webinar where people have come and gone posing their questions. If you've just joined, please feel free to pose a question in the chat, and I will look for that. Try to keep it anonymous because portions of this webinar will be posted online, and we want to respect your confidentiality. So I'm just going to go through the other question that was posed last week, and anybody who's here can type their question in the chat. And I'll try to monitor that for the purpose of trying to answer that. So because we still have a few minutes left. So in one situation, these relate to inadmissibility, refusals, and last resort remedies. These are the hardest files. Before we turn to the hardest files, a quick recap. So far, the through line has been controlling the timeline, the documents, and the disclosure before an officer ever raises a question. In these cases that follow, much of that control is already gone. For example, a conviction or a removal order is on the record, a claim or an application has already been refused, the ordinary routes are closing. Strategy here is about finding the remedy that is still open and using that remedy well. So, the hardest files, arguably criminality, refused refugee claims, and applications that have exhausted the ordinary routes and are groping for humanitarian relief or an appeal. These are where strategy matters the most because the margin for error is the smallest. Let's talk about one, criminal inadmissibility and the timing of a discharge. A client wanted to consult about the consultation followed of a criminal matter, a low-value theft allegation arising from a workplace misunderstanding about consent to take certain items that had resolved with a community service, counseling, and a donation and restitution, with a discharge expected shortly. Her status had shifted over time from work permit to student to visitor. The questions raised here touched on the laws and policies related to criminal inadmissibility, the immigration effect of a discharge as opposed to a conviction, and how an unresolved or recent criminal matter interacts with temporary status. Possible solutions included confirming precisely what disposition had been entered and when the discharge took effect, assessing how that disposition would be treated for admissibility, and timing any further immigration step around the criminal outcome rather than ahead of that outcome. And now a different case. A refused refugee claim headed to appeal. A client wanted to consult about appealing a refused refugee claim. He had come from a country in Latin America, made his claim, represented himself at the hearing, and been refused. The refusal turned in part on the availability of what is the doctrine called internal flight alternative. The idea that he could have relocated safely within his own country rather than making a refugee claim, and on the fact that he had not gone to the police, which he explained by saying people he feared were connected to the police themselves. A deadline for the appeal record was bearing down. The questions raised here touched on the laws and policies related to the refugee appeal process, the internal flight alternative test for presentation at the RAD appeal, and the treatment of state protection where agents of harm are tied to the authorities. The possible solutions discussed included building the appeal record to confront the IFA finding directly, addressing the state protection reasoning, and meeting the record deadline that the self-represented claimant had nearly missed. And now a separate different case, sponsoring a refugee from abroad. A client wanted to consult about sponsoring relatives of a spouse who were refugees overseas, where an earlier overseas refugee case and a sponsorship had already been filed. The questions raised touched on the laws and government policies relating to refugee resettlement, the Convention Refugees Abroad class, and the Country of Asylum class, the difference being government-assisted and privately sponsored refugees, the blended visa office referred program, and the inadmissibility grounds that can block resettlement, as well as the fact that the former source country class had been abolished. The possible solutions discussed included identifying which resettlement class the relatives could realistically fit, confirming the sponsorship requirements and undertakings, and screening early for any inadmissibility that could derail the file. And now, a different case, a refused parent case reaching for humanitarian relief. A client wanted to consult on behalf of a widowed parent whose visitor extension had been refused, whose application for leave to challenge that refusal in the federal court had been denied, and where most of the family was rather settled in Canada as permanent residents, and citizens with one member abroad outside of Canada. Trust in previous council had broken down, and a new humanitarian and compassionate angle was being considered. The questions raised touched on the policies related to H and C relief, the establishment and family reunification factors that support humanitarian compassionate relief, the limits of judicial review once leave is denied, and the bereavement and dependency considerations relevant, in particular to an elderly widowed parent. The possible solutions discussed included assessing whether an H&C application was the right vehicle, given the litigation history, marshalling the family's establishment in Canada and the parent's circumstances, and rebuilding the file on a clean evidentiary footing. Now a separate case, a string of refusals and a route through a spouse's job offer. A client wanted to consult about a situation after a series of refusals. A temporary resident visa refused for the whole family, a provincial rural and investment stream refused for him because the occupational code on the supporting letter, namely a code for a store supervisor classification, did not match his actual experience. His spouse, meanwhile, had secured a positive labor market impact assessment for a food service role, and an agent had told him he and their child could accompany her on her work permit route. The goal was permanent residence. The questions raised touched on the laws and government policies related to occupational classification accuracy in nominee applications, the consequences of a code that does not fit the experience, and family members accompanying a principal worker. The possible solutions discussed included correcting the occupational mismatch that sank the earlier nomination, assessing the spouse's labor market-backed route with the family as accompanying members, and choosing the cleanest path to permanent residence rather than repeating the approach that had already been refused. So in these cases where people posed questions and or consulted, when I look at them, if there is a single thread through all of these, it is this. The facts that look like small administrative details, an expired passport, an omitted job, a name corrected on a birth certificate, a few weeks of overwork beyond the work permission, the date of a confirmation document being delivered, are often the whole case. The law gives officers room to refuse exactly on these points, and it gives us room to get ahead of them by disclosing, documenting, and explaining before the question is ever asked. Spot the issue early, choose the route the numbers and the evidence actually support, and never let a fixable problem become a material misrepresentation. Every scenario you heard today has been de-identified, and every outcome depends on the full facts and the policy in force at the time. Thanks so much for spending the time in the consultation room, and I'm happy to take questions. So if there's anybody left to get the discussion started, since we have maybe a minute or two, there's a few questions worth putting to the audience, which we can discuss later. So that concludes the webinar today, and I thank you so much for joining. Enjoy the rest of your day.